have Vilas now who's called in from Mumbai. Vilas, what's your question?
See, my question is, my father passed away early this year, and he passed away interstate, so that is without a will. So we had issue to tackle in terms of a flat in Mumbai, which was jointly owned by my father and my mother. We are 3 siblings, me and my 2 sisters. So first level heirs are me, my 2 sisters, and my mother. We all the 3 siblings want to release the claim over the property in favor of my mother. When we approached for legal advice on how to really go about, we were given 2 tracks. One was to go by doing a letter of administration, and second track was that we do a kind of affidavit of heirship, and along with that do a kind of a release deed, which we can go and register at the sub-registrar's office. In both the cases, the difference was quite a lot. And we checked with various banks. They accept both the cases. They said first one is more prevalent, or other, succession. I think, release deed is much more prevalent. We were very confused about where to go about. My question is, which one is better to go about, and what are the implications of it?
Sure.
What would you say?
So, Vilas, I think the first option is the correct option. You have to obtain letters of administration for your father's estate. Let me just inform you something. As far as Bombay is concerned, obtaining LOA is compulsory as far as property and immovable property is concerned. So let's not have any doubt. You have to do the LOA bit with regards to the 50% share that your father had in the property. I'm presuming that there was no specific share that was assigned to your father. After that happens, what effectively will the court do is appoint a person. Now, this person will be allowed to administer the estate of your father, which would not only include this property, but also include other bank accounts and other movable items that he may have. So, this person will then execute a document, which may be a deed of transfer or any other document of similar nature. And that document will actually establish the ownership rights in respect of your father's 50% in the property. So what you do is, let me break it up again. You do a LOA, let the person be appointed as the administrator. That administrator will be bestowed with the right to transfer the property to the rightful heir. Now in that document, as you said, whoever wants to give up the rights, as in the 3 siblings, they don't want to contain or they don't want to hold any rights in the property, you can just simply do a release in favor of your mother.
Okay. Also, Avikshit, very quickly, because there are a lot of other viewers who are tuning in, and I'm sure, property and will is something that everybody wants to know about. What is a letter of administration? How does one get it?
See, Kavita, the difference is basically on dying interstate. So if a person dies...
That is if the owner of the property has died without making a will.
Yes.
That is called dying interstate. Yes, Avikshit.
Yes. So what happens is, if you have a will, then you apply for probate. And generally the process is, the will already sets out the person who is supposed to distribute the property. So what the court does is merely appoint or empower that person by an order saying that you are henceforth going to distribute the estate. In letters of administration, what happens is, because there is no will, so you don't have an assigned person who the deceased wanted to administer the property. So then it is upon the person making an application for the letters of administration, where he makes a claim that I can distribute the property on behalf of the deceased. And basically, depending on case-to-case circumstances, and if there are no disputes in the matter, the court will actually appoint the person who makes an application for distribution of the asset.
So you go to court. Which court do you have to go to for this?
In Bombay, it's the Bombay High Court. They have the exclusive interstate
jurisdiction. You have to go to the Bombay High Court.
Yes.
And and across the country, where I'm talking about places where you do not have a high court.
So it will be the highest civil court which will be given the jurisdiction, basically.
Okay, so things to live by. Ideally, if you have a property, make a will. Ensure that it is very clear who stands to inherit your property in the case or in the event of your death. Now, in case there is property in the family where a will has not been made, where the owner has died intestate, what you need to remember is that somebody among the family members can approach the court, the highest court in that area, in the locality, and approach the court and say that I am willing to administer the property and apply for a letter of administration. If the court deems fit, you'll be given a letter of administration, you'll be appointed as an executor, and then you can proceed with distributing the property that is concerned amongst the rightful heirs. So these are the 2 routes available to you. But again, the best thing to do is, If you are living, you can use a gift deed to transfer the property in the name of the person whom you want to gift the property to, or alternatively, you can make a will which can be executed in the event of your death. And if there is property that is intestate, ideally you should not be leaving property. You should not be leaving property and allowing your heirs to do whatever they deem fit with your property. That is not the right way to actually setting about inheriting or gifting property. So the best thing to do, like we keep saying here, is if you have property, make a will.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.